I call this meeting the Judiciary Committee to order. Members, take your seats. Chair recognizes a quorum. Members, today the State Court Administrator will be presenting the Judicial Branch's budget request, and then I'll be presenting a bill, House File 519, relating to civil actions avoiding waiver of liability. There is an amendment. I think we have an amendment to that as well. But first, on to the minutes of February 7th. Representative O'Neill, did you get a chance to look at those again? And do they
We'll look at them right now.
meet with your satisfaction? Well, while you're looking at them, why don't we do the minutes of February 12th? Can I have a motion to approve the minutes? Representative Noor moves the minutes of February 12th. Any discussion? All in favor, say aye. Aye. All opposed, say no. Motion passes. The minutes of February 12th are approved. Are they all good, Representative O'Neill?
Thank you, Mr. Chair. Yes, they are accurate now. Thank you.
Okay, Representative O'Neill moves the minutes of February 7th. Any discussion? Seeing none, all in favor signify by saying aye. Aye. All opposed say no. Motion passes. The minutes of February 7th are approved as well. Did I already say the minutes of February 12th are approved? Mm-hmm. Well, they're approved. Okay. With that, then, Mr. Shorba, please welcome to the committee. On behalf of the courts, please identify yourself for the record and take it away.
Great. Good morning. Thank you, Mr. Chair. Members of the committee, my name is Jeff Shorba, and I am the State Court Administrator for the Minnesota Judicial Branch. I was asked to begin my presentation today by commenting on any impact the federal shutdown had on the Judicial Branch. During the shutdown, there was no immediate impact on the branch. The branch does receive a few grants from the Office of Justice Programs. Those are reimbursable grants, so we did receive notice that payments would begin once the federal government came back online. If the federal government shuts down again, hopefully it would be back online by the end of our fiscal year so that we'd be able to get those reimbursements. So that's a quick update on the shutdown. I'd like to start with a brief explanation of the Judicial Branch budget. The Judicial Branch budget is appropriated to the 3 levels of courts. Our FY 18-19 budget is shown on this slide. In total, funding for the Judicial Branch of Minnesota's government totals less than 2% of the general fund budget. You will see an asterisk on the slide. The Judicial Branch has also allocated funds for civil legal services programs. For FY 18 and 19, that was $27.4 million. The funds are really considered a grant pass-through program. No funds are retained by the Judicial Branch, and I understand that you'll receive a separate budget presentation from the Civil Legal Services Group. The Judicial Council then makes allocations and distributes the funds within each level of court. The Judicial Council is responsible for developing the biennial budget request. The Council considered many important and worthy proposals brought forward by our judges and staff across the state. Ultimately, the funding request Judicial Council approved includes what we consider only the highest priority budget issues facing our courts, as determined through many months of research, discussion, and difficult decision-making. For the Minnesota Judicial Branch, our priority has been and continues to be the ability to deliver prompt justice for the people we serve, and we believe this budget request will enable us to continue our efforts to provide efficient, effective, and cost-beneficial services to the citizens of the state. After careful consideration of many proposals, the Council concluded that the branch's budget request would concentrate in 5 key areas: providing resources necessary to manage the growth in trial court caseloads, addressing the rising costs of providing mandated psychological services, sustaining Minnesota's treatment court programs, improving the cybersecurity of Minnesota's courts, and addressing the Judicial Branch workforce challenges. I will now go into some further detail on each of these individual requests. Our first request focuses on the district court's workload. Over the last 5 years, the Judicial Branch has seen an increase in the number of major case filings and an increase in the complexity of the cases brought to the trial courts. The most marked increases is in children in need of protection or services cases, with a 42% increase, and permanency cases with a 69% increase in filings from FY 14 to FY 18. In addition, major criminal case filings, felonies, and gross misdemeanors have risen by 22%, driven primarily by the increases you see on the slides. Now, these are the cases that require the most judge time. When I appeared before you a few weeks ago, I discussed the distinction between major and minor case types. Major case types are more complicated and more time-consuming. The judicial branch uses what we call the weighted caseload analysis to determine our need for new judges. This methodology has been used in Minnesota since 1980. The process starts by figuring out how much time it takes judges to process certain types of cases. That amount is then multiplied by the number of case filings to determine workload, and workload is then divided by the amount of time judges have to do work to determine judge need. Given that caseloads can fluctuate, the judicial branch does not just rely on 1 year of data to determine need. We use a 3-year rolling average of need when determining the number of judges needed to process cases. Given the current judge need across the state, we are asking for funding to create 2 new judge units. The Judicial Council will determine in March, based on the latest filing data, where these judgeships would be located, and a unit consists of the judge, a court reporter, and a law clerk. So that is the first part of our request.
Mr. Shorba?
Yes.
Why are 2 judge units more expensive in 2018 than they are in 2019?
Mr. Chair, because in the first year there's a chamber setup cost to set up a chamber for the new judge. So we'd have to furnish it and other kinds of things. So there's a little bit initial cost in the first year.
Okay, thank you.
Our next request is for funds to fill the hole in our mandated psychological services budget. State and federal laws mandate that certain services be provided to people who interact with the court system. Specifically, those services include interpreters, psychological services, jury management, etc. The judicial branch is expecting significant increases and already experiencing it in the cost of providing some of these services, but most specifically in the area of psychological exams. This is probably not surprising to you. The number of people entering our courthouses with some type of mental illness continues to grow. And Minnesota statute section 480.182 provides that the courts will pay the court-related costs of examinations for both commitment and under Rule 20 of the Criminal Rules of Procedure. I want to just talk a little bit about Rule 20 examinations. This slide explains the 2 types of Rule 20 examinations. Under Rule 20.01, prosecutor, defense attorney, or the court can request an examination to determine if a defendant is competent to stand trial. And then under Rule 20.02, the court may order a second examination if the defense notifies the prosecution that the defendant will plead not guilty by reason of mental illness or deficiency. In case of misdemeanors, if the defendant pleads not guilty by reason of mental illness or deficiency, or the defendant offers evidence of mental illness or deficiency at trial. In many cases, both examinations are requested and ordered, and there is a right to have those 2 examinations if ordered by the judge. What we are seeing is several pressure points that are impacting the psychological services budget. We've seen an increase in the number of examinations for Rule 20 and in commitment cases. Between fiscal year 17 and 18, criminal Rule 20 examinations increased by 11.5%. In addition, expenses for these cases have risen 48% from fiscal year 14 to fiscal year 18. Some of that is driven by travel cost. We are seeing less individuals able to perform these exams in greater Minnesota. We also had an increase from the Department of Human Services. Their examiners do a lot of these exams, almost 15% of our exams, and they increased their rate by 20%. So our cost per case has risen in the last year by 12%.
Thank you, Mr. Shorba. Chair Considine.
Thank you, Mr. Chair. What are the requirements to conduct a Rule 20? Does it have to be a full-blown psychiatrist, or are there other occupations that can conduct it?
Mr. Shorba.
Mr. Chair, Representative Considine, it does not have to be a psychiatrist. It can be a psychologist, and we have a roster of individuals who we deem are qualified to do these exams, and our courts can then go to that roster and look for examiners. We also, in Hennepin County, have a group of employees who do these exams because of the large number of volume there. And then, as I mentioned, we use in about 15% of our cases individuals licensed to do this work from DHS.
Chair Considine.
Thank you, Mr. Chair. Social workers with an LSISC, thank you. W, can they do them?
No, Mr. Chair, Representative Considine, it has to be a licensed psychologist, licensed psychiatrist, or in some cases, a licensed medical doctor.
Okay. Thank you. Thank you, Mr. Chair.
Representative Liebling, where are you? Oh, Chair Liebling, go ahead.
Thank you, Mr. Chair. And since we're kind of paused on this point, I'm just curious about those that are licensed to do the work from DHS and their rates went up 20%. Are these, just trying to figure out where they are in DHS. Are these people that work for direct care and treatment in DHS, or, you know, can you just sort of explain to me where the interaction is here?
Mr. Shorba.
Mr. Chair, Representative Liebling, most of them are people who work at the state hospitals, and either our individuals are currently in the state hospital while they're awaiting trial, or they're individuals who, because of the state hospital locations, especially in greater Minnesota, are closer to the clients themselves and so can go and do these exams. So they're generally employees for DHS in the state hospitals.
Okay. Thank you, Mr. Chair.
Okay, thank you. Please proceed, Mr. Shorba.
So our budget request of $2.14 million for the biennium will help fill the hole in this psychological services budget that we see in experiencing an increase. So that is our second part of the request. Our third part of the request has to do with treatment courts. The growth in both the number and type of treatment courts operating in Minnesota over the past decade has been significant. This growth is a testament to the sustained popularity of treatment courts nationally and the positive outcomes achieved in treatment courts that adhere to best practice principles. The current funding mechanism is a complex system. The judicial branch funds 31 of the treatment courts. Our FY 18-19 budget is approximately $9.1 million. The remaining portion of the total cost of treatment courts, approximately $15 million, is funded from a combination of grants from the Office of Traffic Safety, Federal Bureau of Justice Assistance, Office of Justice Programs, Department of Human Services, and federal grants. So as you can see on this map, treatment courts are in place or being planned in about 80% of Minnesota counties. At present, there are 61 operational courts, including 11 multi-county programs. The question is often asked, do they work? Research shows that treatment court approach has proven more effective than some traditional court strategies at reducing repeat offenses. This is especially true for certain offenders, such as those having a high recidivism potential. Treatment courts result in more defendants turning their lives around and becoming healthy, law-abiding citizens. And research also shows that when these strategies are implemented correctly, they improve public safety and save taxpayer dollars. Evaluations performed by the judicial branch, as well as many other national studies, have shown the real positive impact of treatment courts. In 2012, the branch released a statewide evaluation that compared drug court participants to similar offenders and found that drug court participants were less likely to reoffend, spent less time incarcerated, reducing costs to taxpayers, and showed gains in employment, educational achievement, home rental ownership, and payment of child support. In 2014, we performed a follow-up analysis to examine whether the positive impact of drug courts on recidivism continued after 2 years, and I'm pleased to report that the findings still hold true 2 years later. In addition to our state court administration evaluations, the Department of Public Safety, responsible for traffic safety grants, which fund many of our DWI courts, recently completed an evaluation of DWI courts, and they found the same thing: reduced recidivism, completion rates above the national average, and savings of taxpayer dollars. In 2017, with the assistance of the legislature, we implemented a funding formula for treatment courts aimed at providing a stable funding source. The judicial branch treatment court appropriation is distributed through this funding formula. The funding formula provides that new treatment courts will be funded through state or federal grants. Once you come into the funding formula, Justice Partners will contribute a 30% cash or in-kind match, and that existing treatment courts and treatment courts cycling off of grants will be funded based on a minimum number of participants, as you can see on this slide. As I noted, most treatment courts start with federal grant funding. When the funding expires, we have to seek sustainability funding to keep these courts open. Our request seeks new funding for 5 existing treatment courts, which have grant funding set to expire during the next biennium. This new funding will allow the judicial branch to add these 5 courts you see on the screen to the statewide treatment court funding formula. That is the third part of our request. Fourth part of our request has to deal with cybersecurity. Last year, over 22,000 public sector cyber incidents were reported nationally, along with 300 confirmed data breaches. The trend is expected to increase as gathering data is a lucrative criminal activity. In 2016, many of you are familiar that prior to the launch of the Judicial Branch Cybersecurity Program, the Judicial Branch experienced 3 DDoS attacks. A DDoS, distributed denial of service attack, is designed to make a network resource or site unavailable to its intended users. The attackers sent hundreds of thousands of requests to access our website, causing the site to crash. In our case, we shut down our public website to enable us to install software to thwart the attacks. One of the attacks resulted in our public website being unavailable to the public for 10 days. Minnesotans who depend on our public website for information, forms, and access to services were unable to conduct their business during the attacks and subsequent shutdown. As a result of the attacks, the branch hired an outside cybersecurity firm to identify our vulnerabilities and help us prioritize efforts needed to mitigate risks. In addition, we sought and received funding to create a cybersecurity unit to develop and maintain an information security effort that will mitigate the branch's risk of major data breaches, data corruption, system outages, document data loss, and cyber attacks. Our transition to statewide electronic filing of court cases, electronic court records, and online sharing of court records underscore the need for a robust cybersecurity program. We are responsible and committed to the safety and security of a magnitude of public, private, and sealed information regarding Minnesotans. We recognize that as the organization's dependence on technology increases, the risk of major outages and cybersecurity incidents become more common, impactful, and costly. To maintain the privacy, security, and legitimate business access of sensitive information, the strength and security of the branch's technology infrastructure is one of our highest and ongoing priorities. The cybersecurity program maintains and ensures the confidentiality, integrity, and availability of information through carefully coordinated information framework, communicated policies, and provides the branch with the necessary flexibility to protect against increasingly sophisticated cyber attacks. As part of our cybersecurity program, we also conduct internal self-assessments. I can't, in a public meeting, go into the details of those results, but I will share with you that we continue to score in the red in many areas. It's a very complicated issue. As you're aware from the media almost every day, the bad guys get smarter, and we need to keep up with them. Such, we are asking for a request to expand our cybersecurity program. This would involve additional staff, but also additional software and technologies to monitor and help protect our network infrastructure in the judicial branch.
Chair Scott.
Thank you, Mr. Chair. I'm just curious, Mr. Shorba, how the judicial branch handles data breaches, if you've experienced one where people's personal information has been exposed.
Mr. Shorba.
Mr. Chair, Representative Scott, I'm happy to say that we have not had any data breaches.
Please proceed, Mr. Shorba.
The final 2 areas of our request address our people. Well over 80% of the judicial branch budget is spent on people, staff, and judges. Without our people, we cannot do the work of justice, and the branch is seeking additional funding to help the judicial branch address 2 challenges: recruitment and retention. During the height of the recession, we were forced to impose a multi-year salary freeze in order to preserve essential court functions while managing difficult budget cuts. Employees did not receive ongoing permanent compensation increases for 5 years between fiscal year 08 and fiscal year 13. At times during our freeze, other state and local government entities provided compensation increases to their employees. We did receive funding to give our employees across-the-board increases the last 3 biennia, and we appreciate the legislature's support that allowed us to end the freeze. We have made, with your support, a concerted effort to improve the competitiveness of the branch's salary structure, but to ensure the salary structure supports a competent workforce and does not fall below the market in the future, the branch must continue to keep pace with our public sector competitors. Currently, 1/3 of those leaving the judicial branch take jobs with other public sector employers. And as competition increases, we're also losing more people due to an ongoing retirement wave. Within the next 10 years, 30% of current judicial branch staff will be 65 years or older. Each year of the staff who leave the branch, 1/3 again retire or exit the workforce. We are requesting a compensation pool of 3.5% each year of the biennium, along with funding for the employer's share of healthcare insurance increases using current MMB estimates. The last part of our request concerns our judges. The judicial branch works hard to attract and retain the best and brightest jurists for our courts. However, we lose the ability to gain the interest of highly competent lawyers if we are not able to keep salaries competitive. In some counties, the county attorney and assistant county attorneys make more than a district court judge. District court judges currently rank 19th nationally, adjusted for cost of living. We certainly do not want to be number one in the nation, but we also hope that we can strive to stay in the top half. The branch is facing challenges in our ability to attract and retain judges. As with our employees, we're seeing a significant retirement wave. By 2022, almost 40% of all judges that were on the bench in 2017 will have either retired or will have turned 65 years old. We are also having difficulty recruiting judge candidates in Greater Minnesota. The number of applicants are down. In addition, in Greater Minnesota and other parts of the state, we are finding that primarily only public sector attorneys are applying for jobs. This is not to say that public sector attorneys do not make fine jurists. They do. However, we strive to retain a balanced judiciary with representatives who have had both public and private sector experience. So the Judicial Council's compensation request for judges is the same as that for staff, 3.5% in each year of the biennium and the employer cost of unavoidable health care increases. Mr. Chair and members, that is the Judicial Branch's 2021 biennial budget request. The request increases our base budget by approximately 6.38%, which is close to what the legislature appropriated to the branch in fiscal year 18 and 19. As I said at the beginning of my presentation, our priority has been and continues to be the ability to deliver prompt justice for the people we serve. We desire to continue our efforts to provide efficient, effective, and cost-beneficial services to the citizens of the state. Our budget request represents what we believe is the increase needed to maintain these service levels. I appreciate your time, and I'm happy to answer any additional questions.
Great. Thank you, Mr. Shorba, for that thorough presentation. Questions from members of the committee for Mr. Shorba? I'm sure. Chair Johnson.
Chair Lesch, Judge Zorba, I'm just wondering what's the reason for I'm looking at both on the judge's compensation request and also the employee, over 200% increase in health care costs from fiscal year 20 to fiscal year 21.
Mr. Shorba.
Mr. Chair, Representative Johnson, the Minnesota Judicial Branch simply tags along on the executive branch healthcare insurance. And so we deal with whatever kind of increase they negotiate with their unions and put in place. Right now, they're estimating the increases for fiscal year 20 to be 5.63% increase, and for fiscal year 21, 5.62% increase. So we just take those numbers from MMB. You'll have to ask them in more detail how they come up with them, but that's what they tell us their estimate is.
Other questions for Mr. Shorba? Representative O'Neill.
Thank you, Chair. You had said very quickly sort of the breakdown of the funding for the specialty courts. Could you maybe provide that breakdown to the committee, even just in an email follow-up?
Sure.
Thank you.
Mr. Chair, Representative O'Neill, happy to do that.
Thank you. Mr. Shorba, I'm trying to get a sense of the problems that we have with applicants in Greater Minnesota, the Greater Minnesota districts. And I'm running into this problem now with a bill that I have to ensure that deployed service members get differential pay. And the only problem I'm running into that with is JAG attorneys in Hennepin and Ramsey. who are also county attorneys. Now, the reason for that is because the county attorneys, as you alluded to, in Hennepin and Ramsey, get paid pretty well, as they have demand for pretty qualified lawyers. And the differential issue that I run into is that JAG attorneys statewide have a uniform uniform pay across the military, across branches. Similarly, judges in Minnesota have uniform pay. So you run into the same kind of situation. The point of this is I suspect that we may always have that problem with county attorneys in metro counties getting paid as much or more than judges because of that uniformity disparity that I'm talking about. Ramsey County can set their own salaries, and Hennepin County can set their own salaries, but we don't have that change for the state. Do you have any kind of response to that?
Mr. Chair, I think there are a couple things. Yes, we are going to have that differential problem. I mean, we have that differential problem in some cases with our staff as well, because we have statewide salaries for our staff. And sometimes we have difficulty recruiting in the metro area because the salaries are not competitive enough. Sometimes it's a little bit better in greater Minnesota. I think one of the other issues with judge recruitment in greater Minnesota is there are fewer lawyers in greater Minnesota. So we're having less lawyers, so it's got sort of a combo issue. The lack of lawyers able to apply, but also some of the salary issues. So I haven't seen your bill. I don't know what you're trying to accomplish. I think I sort of understand you're trying to give a pay differential for those who are members of the military. We've had that discussion in the branch as well. Obviously, judge pay is set by the legislature, so that would be a legislative function.
No, and I didn't mean to make you answer the bill. The bill relates to a deployed service member in Ramsey County who's getting paid a lot less for being on her deployment for a year and a half, and she's going to lose her house because as a JAG attorney, she gets paid less than she would as a Ramsey County attorney, and I'm trying to get Ramsey County to solve that. So if there's anyone here from Ramsey County, get her done, okay? But the question related more to that disparity, like how are we going to solve this? And yet the problem that we have is we have a recruitment problem in greater Minnesota with judges. So despite the suggestion that somehow being a judge would be more appealing because you're getting paid that much more than what the median income is, median household income in greater Minnesota compared to the metro. So I was just wondering about how they were going to solve that, but it was partially a rhetorical question. Any other questions for Mr. Shorba at this time? Seeing none, then, Mr. Shorba, thank you very much for this presentation. We will have ongoing discussions with you. I don't think we have a timeline yet for when we're going to have the bill out, but obviously it'll be after targets, and we will be in touch.
Thank you.
Thank you.
Appreciate your support.
And we also have here Judge Warner, one of my favorite judges. I can't say my favorite judge, right? Because, I mean, I'd probably make other people upset who are listening, but she is from Ramsey County and represents the Minnesota District Judges Association. So as soon as you are ready to gear up with your PowerPoint, you can take it away. Members, also, if you have questions that arise between now and when we get targets or when we do markup, feel free to raise them in committee as well, and hopefully we can get on top of that. One thing about raising questions on the record is that they tend to get paid closer attention to than if you raise them offline and people get back to you quicker. There's a reason for having an open forum on this. There's a fundamentally qualitative difference in having a conversation on the record in public than there is in having them offline. So I invite you to please raise them at the table because hopefully it makes all of us a little bit more accountable. With that, if you are ready, Judge Warner, please take it away.
Thank you, Mr. Chair, members of the committee. I also want to introduce Judge Jonathan Jasper from the 10th Judicial District from Anoka. Judge Jasper was here with me a couple of weeks ago. Judge Jasper is the chair of the District Judges Association Pension and Benefits Committee. The president, which I serve as president of the District Judges Association, we turn over every 2 years. Judge Jasper has been consistent for many years as the chair of pensions and benefits. He actually testified before the Compensation Council, so I asked him to join me. I also want to acknowledge Judge John Hoffman, vice president of the District Judges Association, who is here as well. I also want to thank our colleagues, Judge Greg Galler, Judge Joy Barcher, and Judge Tammy Frederickson, who are covering our calendars this morning. The commitment is only for the morning. We have to get back for the afternoon, but they've covered our calendars so we can be here today for this presentation. So, Mr. Chair, members of the committee, thank you. On behalf of the Minnesota District Judges Association, we have a separate compensation request. Our request for compensation for judges in the state of Minnesota differs a little bit from that of the Judicial Council and the Judicial Branch. The judges are requesting, respectfully requesting, that you consider a higher percentage increase for judges for salary compensation for the next biennia at 5%. I'm going to explain the reasons for our request. I will not do a deep data dive. I've given you some of that information. Last time I was here, I didn't take the time to prepare a PowerPoint, but I'm looking forward to having this done, so I have a little more time this weekend for other things, but you do have a PowerPoint. The PowerPoint will be provided to you electronically as well because the links to some of the information is provided electronically. I also understand you have paper copies. We have paper copies as well. I want to start off by saying that we are not asking for anything less for our staff. I want to acknowledge on behalf of the District Judges Association the quality staff we have working for us. Many times someone will come to court and actually never see a judge. They'll see the staff at the front counter or in the self-help centers. We have good, competent staff, and they're worthy. They're worthy of this compensation request at a 3.5% compensation pool. But I want to focus my comments as president of the District Judges Association on compensation for judges. And again, as Mr. Shorba talked about, the goal is to attract and retain good quality lawyers to become judges. The basis for our request is twofold. It's based on the Compensation Council recommendation from 2017 and an independent economist report. Again, you'll see the link is there to both of those reports, and I'm going to talk about them individually. The Compensation Council was actually enacted, I believe, by statute in 1983. Here, I've got my notes. Compensation Council was enacted in 1983. The purpose is every odd year to establish compensation for constitutional officers, judges, Supreme Court justices, etc. You know that there's been some changes to the Compensation Council role over the years. Actually, legislators' salaries were initially involved in the Compensation Council. That came out 2 years ago, I think. The criteria for the Compensation Council has remained the same, though. The Compensation Council considers compensation paid not only in government services but in the private sector to persons with similar qualifications. Their goal is to determine compensation needed to attract and retain experienced and competent persons for the jobs. I want to comment specifically about the role of the importance of the judiciary having both public sector lawyers, which I was before I came to the bench, as well as private attorneys. You know that judges handle a wide variety of cases, not just criminal, not just civil, but in all areas. So a wide variety of background really helps not only the bench, but really the people we serve. I think I told you last time I was here that, when I talk to new judges, I talk about not just cases, but faces, recognizing that we see people in court, not just cases, not just legal disputes. And it's important when we face these legal challenges that judges have a varied background. I came out of the Washington County Attorney's Office before I was appointed in Ramsey County, because it's by where you live, but it's important to have that varied experience. The difficulty used to be in getting private sector lawyers because, as Mr. Shorba pointed out, especially outstate, we get a lot of public sector lawyers, but actually trends are changing now, and there's many public sector lawyers who are actually making more than judges, and I'll talk about that a little bit. But the Compensation Council, their requirement is to look at both, and I wanted to stress that, look at both. What salaries are not only in the public sector, but in the private sector as well. As I said, the Compensation Council met. They meet in odd years. They did not meet in 2015. So the Compensation Council met in 2017. They actually held 4 meetings. They heard from many legislators. They heard from the Senate Finance Committee. They heard from the House Ways and Means Committee. They heard from then MDJ President Judge Kevin Mark. They heard from Judge Jasper. They also reviewed the independent economist report, Dr. West from St. Catherine's University. The Compensation Council, because they didn't meet in March, made the recommendations I have on the slide here. 3.5% increase for judges in July of 2017 and 2018. But because they didn't meet, they used January 1 of 2019 and 20 to recommend a 4.6 increase. And I just took one quote out of their lengthy report indicating that the Compensation Council felt that these increases would maintain and enhance the ability to attract and retain highly qualified judges from all sectors. When it comes to independent economists, I think we referenced previously that for over 20 years, the District Judges Association has used an independent economist to review and analyze data, but then make the recommendation for judicial compensation increases. I've listed the names of the economists. I want to stress that these economists are not paid. They serve pro bono, and we've been lucky to have the services of Dr. Egge and Dr. Moe previously, and since about 2015, 2016, Dr. Christine West from St. Catherine's. Dr. West provided a report in 2016 that the Compensation Council relied on. She also provided an updated report in 2018 for this request when we go forward to the 2021 biennia. In her report, Dr. West indicates that she recommended a 4.63 increase for 2017. That would have actually corresponded, because she factors in inflation, it would have corresponded to 3% real increases. Actually, the branch received and judges received 2.5%. While that closely tracked with inflation, it did not yield real increases. Therefore, she recommends the 5%. It's interesting to note that, and I'm going to go back. I'm sorry, I'm at the wrong slide. I want to go. It's interesting to note that the 3.5% was reduced to 2.5%. That was the increase that was received. Dr. West noted in her report that that 2.5% increase for the judges corresponded in year 1, in year 2017, to a 0.2% increase. So it wasn't a 2.5% increase. In real dollars, it was 0.2%. Due to higher inflation in 2018, in her report, Dr. West concludes that a 2.5% increase in 2018 actually meant judicial salaries, when you factor in inflation, actually decreased by 0.6%. In her report, Dr. West indicates that she expressed concern between the discrepancy of judicial salaries and attorney salaries, not only in the private sector, but in the public sector. The concern that high-quality attorneys would be dissuaded from taking on the job of a judge for a substantial pay cut. That is the basis of her recommendation at 5%. Is there anything you wanted to include at this time that I?
Well, I think the question to understand on that is just that there was no real increase. I should have introduced, I'm Jonathan Jasper from Anoka, and Mr. Chair and members, there was no real increase the last biennium. And I've been a judge for 13 years. And if you look at that over time, I'm making, after inflation, about the same as I was. And one of the concerns we have when we're trying to recruit and retrain people is salaries elsewhere have gone up. Now, anyone who takes a job out of private practice like I did makes a financial sacrifice for public service. And I made that decision. You guys are well aware of that sacrifice. But the bigger the sacrifice, the harder it becomes to get people to make that jump. And that's the concern with not having actually increasing salaries.
And I just want to add at this point that I've been a judge for 21 years. So is Judge Hoffman. We were in new judge school together. Judge Jasper's been on the bench for a while. 13 years. We're at the end of our careers. We're not starting out. This isn't going to impact me necessarily. You know that retirements, they talk about your high five. This is about the future of the judiciary, and I want to make that clear. This is about the people who are coming in, and in that regard, I defer to the statistics and the numbers Mr. Shorba gave you about the age of the judiciary and the fact that in a couple of years, we're going to have 40% of our judges 65 or older. And you know it's mandatory retirement at 70 for judges. So we've had a significant turnover thus far, and the bench is going to continue to turn over. And this increase is about attracting and retaining good quality people to maintain that quality of judiciary. I wanted to give you the numbers based on questions we've asked before. This is what a 5% increase will reflect. Those are the figures for year 1 and 2 if the judges' salaries are increased by 5%. I also note in this slide that 5% increase is a 1.43 increase in the Minnesota Judicial Branch's operating budget. I use the word approximately, that the judicial branch's budget is approximately 2% of the overall state budget. Mr. Shorba used the word less than 2%. So I provided you this information for just for reference. Go ahead.
Chairman, members, I just want to clarify on that slide. The 5% is 1.43%. The branch is recommending a 3.5%. So the actual increase between what the branch is recommending and the judges is something like 0.4% of the judicial branch budget.
This slide is just to demonstrate. We've talked about compensation in the public sector, comparisons, and there are 9 county attorneys in Minnesota that earn more than district judges. I think what's important to note here is this isn't just Hennepin and Ramsey. This is Duluth, St. Louis County, Carver County, Rochester, and this is 2018 data. I had a conversation with the County Attorneys Association. They're gathering their information to update. I don't have it. My guess is it's not going to go down. It's going to go up. I would also note here that in her report and in her research that she conducted, Dr. West concluded that private sector attorneys at 10 years of experience would take a significant pay cut to become a judge. And when I became a judge 20 years ago, the goal was to look at lawyers who have about 10 years of experience. That was the round number that the Judicial Selection Committee referenced, because 10 years that gives you a good amount of experience. And in her report, Dr. West concluded that in the private sector at 10 years, it's a significant pay cut for anyone to take a job in the judiciary.
Chair Liebling?
Thank you, Mr. Chair and Judge Warner. I'm glad you're talking about that because I kind of had a question, and I wonder if you have data that you could give us now or even later on the average and the median wage for lawyers in private practice. Because I have a son who's in that category, and I don't think he has quite 10 years of experience, but he's getting there. And, I just wonder, because I think that often the public thinks that lawyers in private practice are making a lot more than they are. And so I'd really like to have the data on that, just to give us some context for what you're talking about. Also, I wonder if you could tell us anything about the number of attorneys who are graduating from law school now, because, we are seeing a lot of changes in trends kind of across the board in our economy about people going into different professions. Law school has remained very expensive. I know sometimes there was a drop-off in law admissions for a while. Maybe that's regained. But when we're thinking about the future of the judiciary, obviously that has to be fed by the future of the legal profession generally. And so I'm just kind of curious if we know what those numbers are, what those trends are in terms of just people becoming lawyers, period.
Judge Warner?
Mr. Chair, members of the committee, Representative Liebling, thank you for your questions. I will, in full disclosure, note that I do know your son. Well, I wanted, David was a law clerk for Judge Tom Mott in the 2nd Judicial District, and we officed on the same floor. I knew him well, filled in for me. We'd love to have him on the bench, by the way. And he's getting to that 10-year. But I would, he's a good young man. And I would indicate that there is some data from 2018 in Dr. West's report. And I will make sure that I pull that together as it relates to private sector lawyers. She actually broke it down into larger law firms, mid-sized law firms, and so that data is available. I may not have presented it as well as I could have, but I will get that together for you in a separate, if I can do it by email, I'd appreciate that. The other question is you asked about law school graduation rates. That's not something that we monitor closely. However, it's something that we're aware of. And you're absolutely correct. The enrollment in law schools has declined. I know the law schools in the metro area are still, well, I shouldn't say. I know that there was a decline. My understanding, without knowing the numbers, is that it's leveling off and perhaps increasing, but I don't have the numbers. But you bring up a good point. In order to become a judge, you have to be a lawyer. You have to be a lawyer in good standing. And if our pool of lawyers is diminishing, obviously the pool of candidates is diminishing. And again, I don't have the numbers, but we have a judge in actually the 10th Judicial District who used to be in administration at one of our local law schools. And she's really well aware of this issue. And before I answer your question in any more detail, I'd like to consult with her and get the data from the law schools and answer your question in more detail.
Thank you, Judge Warner.
Mr. Chairman, if
We're
I
gonna-
could.
Oh, sir, I'm sorry. Yes, go
Thank
ahead,
you.
Your Honor.
I was just going to say, I'm the fool who's got a law student for a daughter, and it's really expensive. It's terribly expensive. There's actually been a bit of a rebound in applications that they attribute to national political drama. Most people who go to law school don't go there to get rich. They go there because they think they can make the world better. And we saw a huge uptick after Watergate, and there's now an uptick because of the national political drama.
Judge Warner, you know, the brilliance of Chair Liebling's son notwithstanding, Looking for judges with 10 years of experience makes me nervous, just the sound of it. I'd like a little more.
Well.
But that said, we have questions from Chair Johnson and Representative Grosso. Go ahead, Chair Johnson.
Chair Lesch, Judge Warner, I'm just wondering, you talked about the difference between private sector lawyers and stuff. One thing that the private sector lawyers do not have, that which can be attractive to becoming a judge in the public sector, is our pension system. We have a very good pension system that's actually overall in pretty good shape compared to a lot of other states. Our pension commission does a very good job monitoring that. With this compensation package you're putting together with the numbers you had, did you also figure in that you had that 1.68% or something like that affecting the judiciary budget? Did you also factor in the costs of the state and the budget with the state share of the pension increase?
Judge Warner?
Mr. Chair, Representative Johnson, I would, when it comes to figuring in, what I will tell you is the overall increase is a 0.42 between 3.5 and 5, and that's overall. When it comes to the state contribution to the judge's pension, I do want to defer to Judge Jasper. He's been working with this a lot longer than I have, so Mr. Chair, with your permission, I'd like to have Judge Jasper talk about that.
Thank you. Chair, members, actually, we should look to Mr. Shorba, but my understanding in the judicial budget, the numbers they're talking at 3.5 also include the subsequent increase in pension contributions. So ours would be, again, over that. So when we say 0.4, their number, as I understand it, and I apologize, I should defer to Mr. Shorba, includes health insurance and benefits and the pension contribution made by the branch on behalf of the judges. So their whole package would be increasing by 4%, or 0.4%, if that makes sense.
Good, Chair Johnson. Representative Grosso.
Thank you, Mr. Chair. For Judge Jasper. Yeah, you made the comment of some have to make greater sacrifices, or you make greater sacrifices as you go along. Can you tell me about some of these? What are some of the sacrifices you make?
Thank you. Mr. Chair, members, primarily I was referring to financial sacrifices. I believe in the mission of justice that we're all trying to do, and I took a significant financial sacrifice, approaching 50% of my salary when I became a judge. The question is how many people are willing to do that? And along the same lines, I've got a nephew, we're becoming a dynasty. I've got a nephew who works at one of the biggest firms in town, 3 years out of law school, who makes just about the same I do. And most of us, when we go on the bench, have been practicing law 15 or 20 years by the time we go on the bench. So there's a lot of that. As far as scheduling goes, there's lots of sacrifices. I'm scheduled by other people. I can never call my secretary and go, hey, cancel Friday afternoon, I'm going golfing, because there's 100 people sitting in my courtroom. The one that my family keeps pointing out to me is I need to give 60 days notice if I'm going to take a day off, so that I don't have a full court calendar. And my kids are more, let's go to Vegas this weekend. So we lose a lot of our own control of our own time as compared to private practice.
Judge Jasper, I'm just looking at this from my point of view as a law enforcement officer, as a deputy sheriff who served on a task force, a narcotics task force, and a SWAT cop as well. A lot of sacrifices that were made there for half of that. Okay, maybe half of that, of what a judge is pulling in. And the time that I spent with my family, you know. Is there a point where we look at our salary and we become content? We're there to serve, and we're content with making a good living.
Judge Jasper?
Mr. Chairman, members, thank you. And thank you for the sacrifices that law enforcement makes. Their pension also runs very different than ours. But when is enough is the question of when are we seeing it affect recruitment and retention? Because the salaries of the people we want to be judges are going up. And so the sacrifice becomes more. You've got guys like me who might be willing to take a huge sacrifice, but it's hard to do. I didn't come out of law school with $300,000 worth of loans, you know, and kids going to private college that cost $4,000 or $5,000 a month. It's hard for people to make that decision when they're at the age that we would want to recruit them for a judge.
Judge Warner?
I'm going to get into, Mr. Chair, members of the committee, I'm getting into some data in just a minute, but to the representative's question, I just want to say our goal, and this is in Dr. West's report, is we think the top quartile, about a 12, 13%, or number 12 or 13 in the country, is appropriate. And we're not there. And that's, that we think is an appropriate target. So, and I'll tell you, don't, please, you know, if I'm going to talk about 2 G words here. You may think, boy, these judges are greedy. I can't change, well, you're entitled to your opinion. But what I would say is, remember that we're very grateful. We're grateful for the ability to serve. We're grateful that the legislature recognizes and has given us increases. I told you when I was here before, my dad was a district court judge from 1962 to 1987. I'm number 8 of 9 kids. I remember the conversations that my folks had about money. I know I would go to the grocery store and pick up groceries on credit. I know because I've got those records from 1947 to the present from the District Judges Association about what the association did at the legislature, talking about salaries. And I know the history, and I'm grateful that the legislature has recognized the difficult work of judges and has increased our compensation.
Thank you, Judge Warner.
Well, I just want to make one thing clear, Mr. Chair, if I may.
Go ahead, Representative Grasso.
Nobody's saying you're greedy. That's the last thing I'm saying. My question is just, when do we say, you know, we're making a good living, and we're doing well. We're doing well for our kids. We're doing well for ourselves. We're doing well for our future. You know, we can talk about debt and all this other stuff, and my kids also serve. They keep moving forward. They keep serving. They serve in law enforcement. They serve in the military, and you know they've made good decisions to where they don't have a pile of debt on them because they have earned that and worked for that. So it's there's nobody saying you're being greedy.
Thank you.
And I would say that we were going to end this 5 minutes ago so we could get into the bill, but Chair Johnson has a question. Before that, I would just point out, Representative Grasso, anytime folks come up here, there are questions about what kind of wages or benefits package folks get, especially the positions we have authority over, public positions. I think early on, when I came in here as a brand-new prosecutor and I was sitting on this committee, I had questions about the vacation time that judges got, because I'd have to bump my calendar around like, wait, you get that much vacation? And it's, you know, and we also have people come to the committee saying, why do military and law enforcement get to retire after 20 years and get to take a pension and pick up another job and make boatloads of cash? I have people criticize that, and we have to explain to them, well, guess what? Prison guards and law enforcement, your bodies get beat up after that much time, you can't do the job. And it's difficult to teach people about that, too. So I just wanted to point that out. Chair Johnson.
Chair Lesch, just got one little short comment. Judge Jasper, you hit the key word on the head, or you nailed it. Why do we watch this carefully? Because we want the type of judges that you are. I worked in the 10th Judicial District as a law enforcement officer. In fact, you know my father-in-law very well. You are the type of judge we want. The judges we want are the ones that are not there to make the money. They're the ones that will do the sacrifice for the good of the people. And that's the type of judge you are, and I want to thank you for that.
Mr. Chairman, members, thank you.
Thank you. And please continue. I know you have a few more pages on your presentation. Please proceed.
I will try to make it brief. I just want to indicate, in this slide, I want to indicate that Mr. Shorba commented that, yes, for the last 3 biennia, we've received increases, and the staff and the judges have remained at the same percentage. And I want to just talk for a minute and remind you that the compensation increase for staff is a pool. It is not a set percentage. It is for judges. So for the last biennia, judges received a 2.5% increase. That is exactly what we received, 2.5%. The employee compensation increases are a pool. And this slide represents to you that there were law clerks, certain unrepresented staff, certain clerical staff, 53% of all eligible employees who didn't receive 2.5%, they received 3% increase. A 3% increase. Above 3%, almost, well, over 26% received above a 3% increase. Court reporters who are a represented group, this is just an example, their increase was at 4%. So what I want to remind you is that we're not talking apples and apples. When the compensation request, the compensation increase request is at 3.5% for staff and 3.5% for judges, the staff request is a pool. And there's a paper for performance merit model system for many staff. That's appropriate. And that's a good program. But it doesn't apply to judges. Obviously, it shouldn't apply to elected officials. So we have a different standard. And I just want to make it clear that when it's a set percentage, that's what the judges receive. For staff, it's a compensation pool. I'm not going to talk about this slide except to mention you have the report there. The United States Chamber of Commerce Institute for Legal Reform rates state legal systems and courts. Minnesota was ranked number 4 in their latest ranking. National Center for State Courts tracks salaries. They update it every year, sometimes more often than that because legislators do set the compensation. I've just given you the last 2 years. General jurisdiction judges are at 25th. Adjusted for cost of living and inflation, we are at 19th. That gets me to my previous comment where, what is our goal? Our goal is to be in at or near the top quartile, and that would be at 12 or 13. And I think a 5% increase gets us close to that. But we don't know what happens in other states. So with that, I want to thank you on behalf of the Minnesota District Judges Association. This hasn't been easy. It's never easy to talk about money. Sometimes my most difficult cases are easier than coming and talking about compensation. But the District Judges Association, again, recognizes that this is the process. And we're thankful for the opportunity. And we are grateful for your work and hearing us today and considering our respectful request for a compensation increase.
We have, thank you, Judge Warner. We have one more question from Representative Mueller.
Mr. Chair, and thank you. I just wanted to ask, because I know Mr. Shorba mentioned the need for 2 more district court judges, and I wondered if the Minnesota District Judges Association takes a position on need for increased amount of judges.
We absolutely, Mr. Chair, we absolutely support that.
Mr. Chair, can I just make a comment too? So I'm a prosecutor, and I've worked on cases involving speedy trial demands. And when we don't have, a judiciary that's able to address those speedy trial demands, there's an extreme remedy of outright dismissal of cases. And I just think that's an important point to note for the need for more judges.
Thank you. Thank you. Thank you very much for your presentation, Judge Jasper and Judge Warner. It's a pleasure to have you at committee.
Thank you.
Thank you, everyone.
Thanks, everyone.
Members, Representative Mueller is going to take the gavel because I've got my bill up, the liability waiver bill. So we are 10 minutes over our time of when we intended to be here. So,
Yep, no problem.
Okay, members, the bill we will be hearing next is HF 519, Ordinary Negligence Involving a Consumer Service Liability Waiver Voided. Chair Lesch, would you like to move this bill before the committee to be laid over for possible inclusion in the Civil Law Policy Omnibus Bill?
I would, Madam Chair, but I would first like to move the amendment to get the bill in the shape that I'm looking for, and that's the 22 amendment, A19 22.
Okay, thank you, Mr. Chair. Does everybody have the amendment? Any discussion of that? Yeah, Chair Scott.
Thank you, Madam Chair. I'm just wondering why the change to just include minor children.
Mr. Chair.
Well, Madam Chair and Chair Scott, I think if the intent was that if there was any question at all about whether or not liability could be waived in this, there really shouldn't be any question about whether we can require a child who doesn't have the capacity to contract to waive negligence. So that's the intent and reason for the change, is to maybe make it a little bit more palatable for folks who had any questions. We didn't anticipate there'd be any questions about it if there were. We offered this amendment.
Thank you, Madam Chair, and I guess I'll reserve the rest of my questions for when we get to the full bill.
Okay.
Thank you.
Thank you. And Madam Chair, I'm not going to go into much detail on this, but on the question of liability waivers, we kind of take them for granted.
Yep. Mr. Chair, I think we need to still vote on the amendment
you're right.
to make
Okay.
sure that we get the bill in the position you want it. So
Thank you.
all those in favor of the motion to put the form in the bill the author requires, please signify by saying aye.
Aye.
Opposed? Motion prevails. Amendment is adopted. Go ahead, Chair Lesch.
Thank you. On the question of whether or not you can waive your own ability to make a claim for negligence, most of us take it for granted because the law has been so thoroughly developed over the course of the past several hundred years of this country, and it's why you don't worry about if you're going to get salmonella when you eat the egg salad sandwich down at the Dodd cafeteria, or when you send your kid to a preschool. You know they are conforming to certain standards, because if they don't, they're going to be held liable. There are certain organizations who do not want to be held accountable, like you and I do, for our actions. And it may be said that they believe they have good reasons for that, because to do that would put them in a bad position. Now, everyone here around this table engages in activities that involve different levels of risk. And I don't know if too many members of this committee have done as many risky behaviors as I have, including the skydiving and I do a lot of stupid stuff, Madam Chair. Okay, and a lot of that stupid stuff requires waivers of liability for good reason. But there also are limits to what should be allowed in those waivers, because we still do expect that when we engage in those behaviors, that people who are responsible around it are also following the rules. So I'll give you one example. When I was down at Fort Benning, Airborne School has a separate MOS of individuals that wear the red cap who pack the parachutes. These are the parachute riggers. And a parachute rigger is its own MOS. And you can imagine the requirements that go into packing someone else's parachute, because all the airborne soldiers put these packs on with the expectation that they're packed right. So guess what the riggers have to do? Every quarter, they have to go out and they have to jump with the same chutes that they packed. Okay? They don't get a waiver. because if they screw up, somebody dies. A soldier dies. Okay? Imagine the riggers saying to everyone else, all the other airborne soldiers, oh, sorry, you had to sign a waiver. No, they have to share the responsibility for this. So that's fundamentally what this bill was about. We are modifying it through the amendment to say that, you know, this involves, you cannot waive the liability with respect to minors. But with that, I'll introduce Mr. Carlson, who can explain more about the bill and our reasons for it.
Go ahead, Mr. Carlson.
Thank you, Madam Chair and members. My name is Joel Carlson. I own a legal research and government affairs business in St. Paul, and I'm here on behalf of the Minnesota Association for Justice. I'm standing in for one of our members, Chuck Sleen, who's actually in court today on a liability waiver for a child and is unable to make it. So over the past several sessions, we've had a lot of discussion about these ever-expanding waivers of liability. And I want to make sure that we're clear about what we're talking about with the bill as it's amended. We're only talking about those instances where someone attempts to waive their own negligent conduct that results in an injury to a child. That's what the amendment does. It just limits it to children. And, you know, the first time this issue surfaced as a legislative issue was in 2010. And that's when we learned about injuries happening quite frequently at inflatable bounce houses and places where you would take your kids and drop them off to go and play in the inflatable bounce house. And the legislative response to that in 2010 was the adoption of, and I think it's in your packet, Minnesota Statute 184B.20. And that required certain safety protocols. It required operators to maintain their equipment. It required them to maintain liability insurance. And importantly, if you look at the bottom of that page in your packet, you will see that if they have a waiver of liability and it's signed on behalf of a parent for a minor, if it waives liability for negligence of the owner's or employee's conduct, it's void as against public policy. That was the first time the legislature really waded into this problem. But since that time, we haven't really seen behavior change. You also have in your packet a release and waiver of liability for a bounce house that was just printed off the internet yesterday, and yet they still tell parents that you're waiving your right to bring a claim, even though that's not what the law is in Minnesota. So I think some of these waivers put people on notice that they never have a legal claim and they just ignore their rights, which I think is unfair. But as you can see, they're still misinforming parents about what the real status of the law is. The other release that I put in your packet is from Spirit Mountain, and I just wanted to bring this up only so that you can see how expansive they have become. Now, you waive all rights in this particular waiver, including you waive your right to have a claim when Spirit Mountain provides medical care to you, even if it's negligent. That's pretty expansive. And not only that, if you look at the bottom of this waiver, you agree to pay their legal fees and their costs if you have the temerity to bring a claim against them. They have just gone too far. And the reason that I've talked to Representative Lesch, who introduced this bill, not at my urging, but introduced this bill, the reason I asked them to limit this bill to only affect injuries to children is that Minnesota is out of the mainstream as it relates to this area of law. According to the Nonprofit Risk Management Center, there are only 12 states that impose liability waivers for negligence against children, and unfortunately, Minnesota is one of them. And we think that the law has just gone too far in this area where people are negligently maintaining their equipment. They're negligently operating their businesses. They're not training their staff. And yet they are allowed to waive their negligence when a child is injured. And when that happens, either the parent has to pay the cost for those injuries, the taxpayers pay the cost for those injuries, or they just go uncompensated. And we think that the law has just gone too far. In 2013, the legislature, one last point, Madam Chairman, in 2013, Representative Mary Liz Holberg carried a bill to disband waivers of negligence in Minnesota. And we didn't get quite all the way there. But what we did is we changed the law in 604 to say that a waiver for greater than ordinary negligence would not be enforceable. I think I said that right. We're not trying to touch that law. We think that we should let that law develop. There are very few cases that are involved with these waivers. But as it relates to children, we really think that Minnesota should join the rest of the country and just ban these outright so that you're not having some innocent child lose their legal rights simply because not only their guardian might have signed it, the mom who's taken 5 kids to the, to the pool or wherever it is signs it for the kid. We just don't think we think it's unfair that you make them give up their legal rights. Thank you, Madam Chair. We're happy to answer questions.
Thank you, Mr. Carlson. And in the interest of time, members, I think what we'll do is we'll hear from all the testifiers first and then answer questions at the end. So with that, I believe we had 4 people who said they opposed the bill. And if you want to all come down so we can kind of do this as quickly as possible, please, just all be ready to go here. I have Dorian Grilly up first. Okay, great. If you could please state your name and go right ahead. And the others on deck are David Bird, Bob Johnson, and Kevin Gray, just so you're prepared. Thank you. Go ahead.
Madam Chair, members of the committee, my name is Dorian Grilly. I'm the Executive Director of the Bicycle Alliance of Minnesota. We're a statewide organization with members in every county and over 200 cities. We have affiliated groups or local chapters in St. Paul, Mankato, Albert Lea, Fergus Falls, Duluth, Moorhead, and Rochester. And we partner with all of these groups to host events, big and small, and of course, we use waivers in all those events. The 2 biggest are the St. Paul Classic with 6,000 riders and the Mankato River Ramble with 1,800. I'm here to testify against House File 519. We feel strongly that the existing language in Minnesota statutes 604.055 debated and agreed on in 2013 adequately balances consumer protection and the interests of nonprofits and businesses and should be preserved. The changes proposed in House File 519 could threaten our operations and make many of the things we do cost prohibitive. In addition to bicycling events, one of our primary mission-driven activities is to train FIAD and health educators around the state to use an elementary school safety curriculum called Walk, Bike, Fun that we developed in partnership with Blue Cross Blue Shield of Minnesota and MnDOT. The teacher trainings involve riding bikes, and so does the classroom implementation. Needless to say, the school districts use waivers that they get their parents to sign, kids' parents to sign before they take kids out on bicycles in their communities. There are also many other nonprofits that host bicycle fundraising events that I'm sure you've heard of. One you may not have heard of is the Minnesota High School Cycling League. In less than 10 years, it has over 80 teams, 2,500 participants, and it was estimated that their state championship race held at Mount Cato last fall had an economic impact of over $500,000 for that weekend event. In 2015, a MnDOT study found that participants in Minnesota bicycle events supported $14.3 million in economic activity, including $4.6 million in labor income. Our big event, the St. Paul Classic, does generate some income for the Bicycle Alliance, but it's really intended to be a community celebration of everything that's cool about St. Paul. It generates comments like, the Classic made me want to move to St. Paul in our post-event survey. We carry $3 million in liability insurance as a requirement of the city of St. Paul, but our insurance carrier requires us to have all the participants sign waivers. They don't require us to make them wear helmets. We require the people to wear helmets, but the insurance carrier doesn't require helmets because it's not the law in Minnesota, but we do. Our other big events in Mankato and St. Joseph are also meant to be community celebrations. We also support smaller events in Rochester, Duluth, Fergus Falls, and a new annual event in Albert Lee, and we are considering a bigger event in Rochester in the coming years. So finally, I'd like to say that it's the Bicycle Alliance's goal to make bicycling easy, safe, and fun for everyone. We take safety very, very seriously. Cumulatively, our events have had over 100,000 participants in the last 10 years, and we have never had a life-threatening or disabling injury. We'd like to continue that record and continue to teach bike safety to elementary school children. The Walk Bike Fun curriculum currently is reaching 60 to 70,000 kids a year. I think that's a very important program. So committee members, the Bicycle Alliance of Minnesota asks you not to support House File 519. Thank you.
Thank you, Mr. Gurley. If you can just stay close, and we'll have Mr. Byrd, and then please keep in mind those still wanting to testify. We have about 5 minutes total left. Thank you.
Thank you, Madam Chair. My name's Dave Byrd. I'm the Director of Risk and Regulatory Affairs for the National Ski Areas Association, which is the umbrella trade group for all ski areas in the U.S. We're based in Denver, Colorado, but I'm a native of White Bear Lake and a graduate of the University of Minnesota Law School. We oppose, as an industry, both at the national and here at the state level, House Bill 519 on releases. The ski industry has been using releases for decades, including minor releases. And I just want to comment why this is an important bill such that the National Trade Association would come in. All the surrounding states, including the province of Ontario, enforce waivers at the adult level. And Minnesota does support and endorse waivers at the minor level. 30% of all skier visits in Minnesota are with minors. That's about 400,000 minors participating in skiing in Minnesota. Lindsey Vaughn, Minnesota's own, grew up skiing at Buck Hill as a child. And when she was racing before she became a gold medalist gymnast or skier, she signed waivers like all of our children have been signing in these recreational activities. Representative Lesch talked about accountability. And skiing is all about personal responsibility because 99% of the injuries that happen are the result of individual human error. We need to protect the right to continue to use minor waivers. The 20 ski areas in Minnesota are the economic engines of the rural communities that they're based in. Wild Mountain in Chisago County, the largest employer in the county. Lutsen Mountain in Cook County, the largest employer in that county. And our ski areas are expanding dramatically into summer activities which require the use of waivers with children. Mountain biking is hugely growing. Minnesota is one of the leading states for downhill mountain biking, and the ski areas are leading that charge. So we believe that parents, the law in every state presumes that parents act in the best interest of their children, and that if they're voluntary and informed on what they're waiving, parents should have the right to control the custody and destiny of their children, including their involvement in risky activities like skiing. So I'm going to yield my time to my other members who oppose this bill. I would just say the economic importance in the rural community of ski areas is hugely important, not just in Minnesota, but around the rest of the country. So thank you very much, Madam Chairman.
Thank you, Mr. Byrd. Great. Mr. Johnson. Go ahead.
Madam Chair, I'm not Mr. Johnson. Mr. Johnson yielded his time graciously to me. I'm Eric Linseth. I am the general counsel at Lifetime Fitness. I'm sure you've heard of our company. We're a large Minnesota employer. We have 142 clubs throughout the nation, but we have 24 clubs located here in the state of Minnesota. We have 200,000 members. About 25% of our members are kids. I wanted just to build on what Mr. Carlson mentioned. There is a history associated with this statute that Chairman Lesch would like to amend. In 2013, a bill was introduced to ban waivers of liability entirely in the state of Minnesota. We worked very hard to reach a bipartisan compromise on that bill. It was ultimately voted on in both the Senate and the House, and it was adopted. In the Senate voted in favor of our compromise bill 61-0, and the House voted in favor 116-17. So there was overwhelming support only 6 years ago for the compromise bill that we struck. It strikes a balance between protecting the rights of recreational service providers to ask consumers who want to participate in discretionary recreational activities to waive ordinary negligence claims. But it protects the rights of consumers to be able to bring claims for conduct beyond ordinary negligence, like recklessness or gross negligence or wanton conduct. That was a balance that the legislature supported only 6 years ago. I will say that we design our health clubs to be as safe as possible. Safety is our first priority. But we also want to inspire kids to get off the couch, get outside of their video games and Instagram, and come in and use our services. We have rock walls, we have water slides, we teach martial arts. We have all kinds of programming where kids are in contact with one another. And so kids inevitably are going to be injured. We ask parents to be able to sign an agreement with us in which they agree to waive their ordinary negligence claims. I want to say that we're not alone. Obviously, we've talked about public entities like school districts and cities that use waivers. There are many small businesses in all of your districts that put recreational services on for constituents in your districts, and they are asking for parents to be able to sign waivers to participate in events, whether it's youth sports, whether it's a single skill like learning martial arts, whether it's going into the boundary waters, right, being led by an outfitter up there. I will say even one of the preeminent plaintiffs' lawyers in town, Jim Schwabel of Schwabel, Getz, and Sieben, utilizes a waiver for his own property. He is a gentleman, and he is extremely gracious to allow people to access his own land on Granite Lake in Annandale, Minnesota. And he asks folks who live on that lake who want to come onto his land and go four-wheeling or play bocce ball or go fishing to sign a waiver of liability, waiving ordinary negligence, and in fact waiving gross negligence. So as Mr. Carlson said, if the bounce house is misrepresenting the law, so is the preeminent plaintiff's lawyer misrepresenting the law. I only offer it as an example to say I don't think that Mr. Schwabel should have to stop using a waiver. It's a way for him to mitigate and manage his risk, and it is a way for every other recreational service provider in the state to likewise manage their risk. Thank you.
Thank you, Mr. Linseth. And Mr. Gray.
Thank you, Madam Chair. I understand our time is short, so I will be brief. I'm an attorney. My name is Kevin Graham, an attorney from St. Cloud, Minnesota, and I'm here representing the Minnesota Defense Lawyers Association, which is an organization of attorneys who represent individuals and businesses in lawsuits claiming personal injuries and property damage and matters of that sort. I've been asked to point out to the committee, Madam Chair, that each of you do have a list of other organizations who oppose the bill that's before you today. It's a two-page list of a number of organizations, including ski organizations, biking organizations, motorcycle clubs, and the like. I just want to speak very briefly. I don't want to repeat what's already been said. From a practicing attorney's standpoint, representing people in these types of cases, we perceive the current law as having a gatekeeping role in the legal field. It eliminates those cases that involve common law negligence or general negligence, but still allowing those claims that involve more egregious conduct as described by the prior witness, willful and wanton conduct, recklessness, or gross negligence. Those claims are still allowed to go forward. And the risk that we see from the perception of our organization is opening that gate wider and allowing the types of claims that just allege general negligence involving injuries to minors, and the number of cases that may come forward and be presented to the courts. We've just heard from the Judiciary about the problems that they have with manning the courtrooms and the number of judges that we have in the state. This is going to result in an increase in litigation, and those claims cost the businesses money, whether it's increased insurance costs or time away from their business. Many of the people that I represent in these cases are small business owners or individuals who simply don't have the time or resources to defend the types of claims that will result from this. So thank you for your time this morning.
Thank you, Mr. Gray. I think before we open it up to the audience members, we can take some questions. Right now, we are at time, actually overtime. Chair Johnson, did you have a question?
Madam Chair, I'm not sure who could answer this question, but I'm looking at this list of the, and it brought up some questions. One of the people on, one of the organizations on here is the, where is it? The Minnesota School Board Association. And I was thinking, why would they be wondering it would be a problem? One of the greatest things we have in this state is the high school sports programs for the boys and girls, learning different things. A big event in is the high school basketball tournament, when we always get that blizzard. Now, when I was in sports in school, we had to sign waivers. And I have a bad feeling that in fact, I know right now we still have to sign waivers. We have to sign waivers for some of the fastest growing sport in high school, which is trap shooting. My father-in-law owns a bowling center, and for the high school kids to come in to participate in the bowling program, they have to sign a waiver. I have a bad feeling, and maybe one of the testifiers could explain, if this goes forward, how bad is that going to hurt our high school athletics situation across the state? And is it going to completely shut it down?
Chair Lesch, did you have a response?
Well, I'll answer for them. They'll say, yeah, it's completely going to shut it down. No more high school sports if you can't sign waivers. I would say the folks coming at this argument are coming at it from two completely different sides. There's the boogeyman. If we change it, everything's going to go to heck. And, you know, I will say from my perspective, I appreciate the folks that came up and testified. I don't believe that they disbelieve what they're actually saying. Okay, I think they came up here and they actually believe what they're saying. However, I would note, Mr. Grilly bragged about Mount Cato, $500,000 they got in, $3.4 million for one event, $4.6 million for another event. All this local infusion of money into the economy. They carry $3 million in liability insurance. But if a kid gets injured, if a child is injured for something that they did, well, it's not our fault. I mean, we're willing to have our cake and eat it too with making all this money for the local economy, but we don't want to be held responsible if we do screw up, so we're going to make you all sign a waiver. And I would also note, Chair Johnson, that Mr. Byrd cited that 99% of injuries are the result of personal error. Remember, and Mr. Carlson, correct me that I'm wrong, but the big insurance attorneys for the ski hills or whomever else only have to prove that it's over 50% the fault of the skier. Am I right? Am I right, Mr. Carlson? And there is no recovery. Zero. They just have to prove that it's over 50% your fault, and you get nothing. You get a big goose egg. You get to be a paraplegic for the rest of your life. Someone forgets to move their snowmobile in the middle of your ski path, and a 15-year-old kid barrels over and can't walk for the rest of his life. And guess what? You signed a waiver. Too bad, so sad, go away. There's something I think that's a little bit wrong with that. So, yeah, I'm sorry I gave you a rhetorical response on that, but yours was a little bit of a rhetorical question, too. So.
Madam Chair.
Mr. Carlson, briefly, please.
Yeah. Representative Johnson, one of the things in drafting is always a problem here. We are amending Section 1, but you don't get to see Sections 2, 3, and 4 in the bill that you're working on. But if you do happen to look at those, you will see that Subdivision 4 of the very section that we're dealing with specifically says this does not apply to any claim against the state or a municipality, including the high school league, including our schools, under Chapter 3 or Chapter 466. And so this does not apply. I believe that the list you're looking at might have been generated in 2013 when we first had this fight, but it doesn't apply to them in any way right now. So I just point that out. The statute doesn't apply to them.
Yep, we need to move on to some others. Chair Scott.
Thank you, Madam Chair. And I'm just wondering, I would like to bring back Kevin Gray to the table.
Mr. Gray, go ahead, Chair Scott.
Thank you, Madam Chair. And I'm just wondering how this bill will affect, we have a lot of community sports activities, kids soccer and those sorts of things, and even youth summer camps. And I'm wondering how those entities would be affected if this bill would become law. And also, we have city skate parks and that sort of thing. So if you want to elaborate on some of those.
Well, I think Madam Chair, with respect to the, and Representative, with respect to the claims, the types of claims you described, I think those are the claims that we see as being problematic, the ones that involve summer activities, recreational activities, where an organization is bringing kids together for a camp or that type of a situation. Typically, a lot of times those are run by nonprofit organizations that may not have the ability to go out and buy $3 million worth of liability insurance or that type of coverage. And under the amendment that's proposed today, they are now potentially liable for an injury that occurs to a minor when they're under their control for general negligence. Keep in mind, they can still be sued under the current law if it's shown that their conduct rises to the level of gross negligent or willful or wanton behavior, something reckless by the provider of the service. But the law opens that gate wider and allows claims for ordinary negligence. So yeah, I think there is exposure there, and that's the type of claim that we see as a risk going forward.
Madam Chair, thank you. So I'm wondering, first of all, I wish the Minnesota tourism folks were here. We heard from the Bicycle Association, which was very telling, just how many people and young children even participate in their programs, and this would be affected. But I'm wondering, from a commerce standpoint, summer camps in these places, they're going to have to, I'm assuming, the options for those entities is going to be either to raise their cost, because they're going to have to buy a huge, expensive insurance policy. So they're going to either have to raise their costs, which, for these kids programs, to me is problematic, especially. A lot of these, I know there's scholarships and different things for a lot of underprivileged kids to go to these camps and so forth, but that's who's going to be hurt by this law, is either the camps are going to go away, or these camps are going to have to buy really, really, really expensive liability policies and raise their rates. The other question is, can a camp like that, can a youth camp, can it get a policy to cover ordinary, or whatever we're calling it, general negligence?
General negligence.
Yes.
Madam Chair, Representative, I'm not an insurance professional. I know there are other people here from that industry, but from my experience, I think they probably can get that coverage, but coverage is always going to be based on risk. Your premium dollar is going to be based on what the insurance company perceives the risk to be. And if this law is allowed to go forward as amended, the insurance industry is going to interpret that risk as being much greater, and the premiums are going to reflect that. And I suspect that the premiums would go up astronomically for those types of programs.
And Madam Chair, if I could I have Mr. Johnson come down to the table and ask that question?
Chair Scott, I think we're well over time right now.
Madam Chair, this is an important issue, and I would appreciate hearing from the courts and stuff. I know that went a little bit longer, but this is an important issue, so if we have to come back this evening, I'm fine with that, or maybe we need, I don't know, Chair Lesch, I feel like we need to have a thorough conversation on this topic.
Yeah, we are, Chair Scott, we are laying this bill over. So I'm wondering if maybe Chair Lesch could address, are we going to have another opportunity for more questions? And I still haven't opened it up for the audience yet, too.
Well,
and I want to make sure we have a chance.
There will be the omnibus bill that will happen. Also, if Chair Scott has questions for Mr. Johnson, she can ask those offline and bring those up at the time of the omnibus bill as well. But we went 10 minutes over with the courts, and we're at 12 minutes over now for overall, so I think we've more than made up the time. That said, I don't disagree with Chair Scott that the bill needs a thorough vetting. I just don't know if we can do it now.
Mr. Chair, Madam Chair, Mr. Chair, would we have time to take this up, finish it someday, what's today, Wednesday? tomorrow, or we can't do it tomorrow, but at some future date, next week, late next week?
You mean, Madam Chair and Chair Scott, you mean like have a second hearing for it, you mean?
Go ahead, Chair Scott.
Madam Chair and Mr. Chair, yes.
Well, I would not anticipate that we would have another full-blown hearing for this. I think I think there's a lot of rhetoric, and if we have like actual stuff that's going to be put forth that's valued information beyond just rhetoric, I think that's very valuable. But I'd like to get that narrowed down before we did it. So I'd like to see I'd like to have it be specific and maybe get to. I know the folks that came down today, what they were going to say, I already knew what they were going to say. They said the same thing that they always say. If there are folks who are going to come and testify and say new things or have new concerns or new organizations that want to be heard in, I think that's important for the committee to hear. And then we can maybe hear from Mr. Johnson at markup or something.
Chair Lesch, what about this? Because since we're low on time or past time, if there's anyone from the audience who hasn't testified who wanted to yet, would you raise your hand? I see a couple people, Chair Lesch. So what?
Bring them down.
Yep. Wanting to do it right now?
I mean, yeah. I mean, I guess we can find out if they're paid lobbyists who are here all the time, or if they're like, if this is their job, or if they're actual citizens who have an position on this. That's more relevant. You can have them introduce to say who they represent.
Please go ahead and state your name for the record and tell us who you're here with.
Thank you, Madam Chair. I'm Tom Humphris. I am a citizen. I am not a paid lobbyist. I'm out of Jordan, Minnesota. I am here as a member of the Amateur Riders Motorcycle Association. We are an organization that helps provide opportunity for riding off-highway motorcycles in the state of Minnesota. And we see this as a threat to providing opportunity to have, with the amendment, youth involved in our sport and our activity. We have experience with statute changes that have dramatically impacted youth involvement in our sports. We had a bridge that collapsed here in the state of Minnesota, and the legislature passed liability limit changes for local municipalities in the state, and that pretty much impacted us. I mean, it was very hard for us to get events and get insurance, because we have to carry insurance when we run events on public lands, and we have to cover the state's or the municipalities' liability limits. It took our insurance rates and like tripled them to go to the $1.5 million requirement. We had a coalition working with multiple different recreational groups out there, rollerbladers, bass fishing, that type of stuff. The bass fishing associations told us they were not going to hold bass fishing events in the state of Minnesota until that was corrected. We led a charge to get that law adapted. We were able to get the law changed that if you were a nonprofit involved in providing recreational opportunities, that we were able to move the liability limit back down to $1 million for the state and for the municipalities. And that's what we usually need to ensure. We were affected by a national law that was, we referred to it as the lead law. Unfortunately, I do not remember the actual statute number, but that classified off-highway motorcycles, bicycles, library books, everything as hazardous toxic waste because they contained X parts per million of lead. They left out the fact that the lead needed to be ingestible or absorbable. And part of the reason that was impacting to us is that a lot of youth motorcycles are made at a price point using recycled materials, metals in the frames and such, and they could not guarantee the parts per million of lead in that. So they were taken off the market for a few years. So we are just now seeing youth activity, youth involvement growing again in our sport. It's taken years to get back to that, and we see this as something that would kill us. It would be something that would make it where our clubs and our promoters couldn't take on that risk. Because in my research, I'm not a lawyer. I'm an IT professional by trade. I need to thank my employer for letting me off work, and I have a call that started 2 minutes ago. But I did some research on what is ordinary negligence and looking that up the other day and looking at some legal websites. And that was defined as examples of things like you wiped up a spill out in the hallway, but you didn't put down a wet floor sign. That was ordinary negligence. It wasn't egregious activities. Those are still covered from my understanding here. It wasn't people doing things maliciously or things like that. It was people attempting to do the right thing, clean up a spill in the hallway. And now they were going to be exempt if this was an organized event where they had signed a waiver. So it's that type of activity is what I see as being affected here. So to me, this is really harmful to youth involvement in activities, the way it's amended. Prior to the amendment was really harmful just to activities in general. And that's what we do. It's a hobby for us. We're passionate about the sport. We're passionate about getting the youth outdoors. We're passionate about getting families together and hanging out together. And I see this as a threat. So thank you.
Thank you so much. And I think there was one other person. Yep, come on forward, please. State your name and who you're with.
Thank you, Madam Chairman, for this little extra time. I'll be real quick. My name is Jim Winterer, and I'm from St. Paul, and I'm here representing the Upper Midwest Trials Association, which sounds like a big organization, but we're really small. It's 50 years old, and it's a off-road motorcycle sport where it's not racing around a track, but it's where you go over obstacle courses like rocks and things. It's a very, very family-oriented organization that about 30 years ago was failing because we weren't highly organized. We didn't have any liability protection, and no one wanted to be an officer. We joined the American Motorcycle Association primarily to use their risk management program. So we go to school for risk management, we get insurance for all our events, and we take the safety end of things very, very seriously. As I said, it's very family-oriented. Mostly we have families in this, from little kids, up to great-grandparents. And we have special release forms for minors. And I can say, from what I've heard today, that would be the end of the family part of our club. It might, because there is so many families, if this was enacted, we just are this small club, but it would probably be the end of the club, I'm afraid. So thank you very much for letting me add this to it.
Thank you. I've learned a lot about motorcycling activities today. Thank you. Chair Lesch, did you have some closing comment?
Yes. I would note that members, when this bill, actually a much broader bill, was brought forward by former Republican Representative Mary Liz Holberg, that these same arguments came up. Even under the compromise language, we were told by industry representatives, all of whom we heard from today, is that it would kill their organization. No kids would be able to bicycle anymore. No kids would be able to ride an ATV with their dad. The sky was falling. We heard the same exact thing. And guess what? It didn't happen. They're all still here because they're all still running their organizations. They just came up to testify. So I'd ask you to keep in mind. That said, we'll continue to work with folks between now and then. I think I'm in agreement with Chair Scott that this was a little truncated, even though we went over time, and we should, probably talk a little bit more about it. So we will do that.
Okay, thank you, Mr. Chair. So at this point, we'll lay House File 519 as amended over for possible inclusion in the Civil Law Policy Omnibus Bill. And unless there are any further questions, at this point, the meeting is adjourned.